presentation by Legislative Research and also a hearing on House Bill 2027. Just a couple quick notes. We have the committee rules. These are kind of redrafted, a couple small changes. I think they did address the concerns, comments from the previous meeting. If you want to take a look at those, and then we'll kind of approve them on Thursday. Also, with regards to the minutes, we'll take those up on Thursday as well. But for the committee, we can do minutes a couple different ways. We can provide hard copies at the meeting, or Gary can continue just emailing them out, and feel free to take a look at them in your email, and then we'll just simply ask if there are any changes at a meeting and approve them as is without providing the printouts. Any objections to keeping it electronic with regards to the minutes? Seeing none, we'll just do that from here on out. So keep an eye out for the minutes, and then we'll just bring them up in the meetings and approve them or change them as needed. So back to the agenda for today. We will start with the presentation from Legislative Research, United Or. This is going to be on kind of the changes to the welfare statutes and programs over the last many years. And it's going to take our time. And committee, feel free at any moment during the presentation, if you have a question about a specific program or change, whatever, we'll just stop and address that immediately as far as the question. But don't hesitate to interrupt the presentation to address something that, because sometimes it's hard to wait till the end. Might as well ask when it's fresh in your mind. So thank you. You got it.
Ida Orr with the Kansas Legislative Research Department. And the first caveat I have is that I am not a public assistance expert. There are people that live and breathe this daily and work with all the details. We do have someone here from DCF who works in that area, and she may be the best one to answer some of the specific questions you have if I'm unable to do so.
Real quick, in your packets from today, so these are fresh on your desk today, it's a purple and a blue handout stapled together, and at the top it's in bold KLRD, and the date is on both of them, the dates are January 15th, 2025. Does everybody have those? Okay. Oh, and I'll make sure at the end we'll come back to Representative Barth, your introduction. All right, thanks.
On the lavender copy, we have the 2004 to 2024 public assistance reforms that have taken place in Kansas. And what I've provided is just a really brief summary of what each of those topics were for those enacted pieces of legislation. I will not be speaking from that bill today. That's more for background information for you. If you decide you want more information about some of these that I don't cover today, please let me know, and I'd be happy to provide that for you. I will be presenting from the blue copy, which is entitled Select State Legislative Welfare Reforms 2013 to 2024, and I have chosen some of the major pieces of legislation that impacted public assistance, and we'll be going through those. It is a lengthy memo. I will not be reading it all to you, but I will hopefully just hit the highlights so that you'll be more familiar. It does contain a summary of those major welfare reforms in Kansas from 2013 to 2024, and I provided a bill summary for those particular bills, and then provided in notations reflecting changes that that were made by subsequent law. Starting in 2013, there was legislation introduced, Senate Bill 149, to address drug screening for cash assistance programs. The bill authorizes screening of applicants or recipients for cash assistance programs or unemployment security benefits, commonly referred to as unemployment insurance or UI benefits, for unlawful use of controlled substances or unlawful controlled substance analog. And an analog is essentially a substance that is structurally similar or pharmacologically similar to a Schedule I or Schedule II controlled substance, and which these items have a particular stimulant, depressant, or hallucinogenic effect. And if you're not familiar with the different schedules, Schedule I are those substances that have no safe, accepted medical use in the U.S. and have a high abuse risk. Those on Schedule II have a safe and effective medical use, but they still have a high abuse risk. And then Schedules 3 through 5 have less abuse risk than Schedule II. The Secretary for Children and Families, and as I go through this, I will just refer to her as, or him or her as a secretary, is required to establish a drug screening program, and that was required by January 1 of 2014 for applicants or recipients of cash assistance. The Secretary was to adopt also rules and regulations, and there are no rules or regulations that were located. However, persons would be screened whenever there's a reasonable suspicion that the person is using a controlled substance. If the screening test is positive, the person may request an additional test at a different drug testing facility. That individual is responsible for paying for that test. However, they will be reimbursed if the second test results are negative. If the results of a screening test are positive, the person must complete a substance abuse treatment program and a job skills program, and a person who fails or refuses to complete either program is ineligible for benefits. If the person tests positive a second time, cash assistance will terminate for 12 months or until both the substance abuse treatment program and the job skills program are completed for a second time, whichever occurs later. If a person becomes ineligible due to a screening test, and they're a parent or a guardian of a minor child, the Secretary for Children and Families may approve a protective payee that's recommended by the parent or guardian to receive the payments for the child's benefit. However, if that individual who's selected as the designated protective payee is reasonably suspected to be using a controlled substance, they also can be tested. They must submit to a screening test. And if the test is positive, the secretary will be the one that will select another payee. Starting in July of 2013, first-time offenders convicted of a controlled substance-related felony, as defined by federal and state law, will be ineligible for cash assistance for 5 years, and persons convicted of controlled substance felonies are ineligible for cash assistance for life. Drug screening results are confidential, except for DCF hearings. There's also in this particular bill screening for unemployment insurance benefits. The disqualifications for those benefits are similar to those for cash assistance, except the bill repeals the disqualification for receiving UI benefits if the person fails a pre-employment drug screening. In its place, unemployment insurance applicants or recipients must submit to controlled substance screening tests. Additionally, after a third positive test and subject to federal and state law, applicable federal law, a person is no longer eligible for UI benefits. Other provisions in the bill also added members of the Senate and House of Representatives to the list of employees who are eligible for drug screening if a reasonable suspicion is present, as determined by the Division of Personnel within the Department of Administration. I've included after each of these bills all of the statutes that were somehow amended or repealed. Then in 2013, we had revisions to unemployment insurance contributions, benefits, and administration of the unemployment insurance trust funds. Sub for House Bill 2105 revises provisions of employment security laws, commonly referred to as UI, pertaining to contributions by employers, eligibility for UI benefits, and the administration of the UI system by the Department of Labor. And the bill also adds a statement regarding neutral interpretation of employment security law. Details on this particular law are located on pages 3 through 5. Of note, I'd like you to refer to page 4. Page 4 has the definition of misconduct and also gross misconduct, and those were redefined by this bill. Regarding eligibility for UI benefits, the bill reorganized the existing provisions pertaining to alcohol and drug use on the job and includes 4 substantive changes. The reason for testing changes from probable cause on the part of the employer to reasonable suspicion. Alcohol or drug use is reclassified from misconduct to gross misconduct. An individual tampering with a chemical test is conclusive evidence of gross misconduct. And an alternative definition for positive breath tests includes a reference to test levels listed in Federal Code of Federal Regulations. If a person makes a false statement or misrepresentation, the bill lengthens the disqualification period from 1 year to 5 years. Additionally, there was a change in the maximum benefit amounts. And if the maximum UI is 16 weeks, if Kansas unemployment is less than 4.5%, the maximum is 20 weeks if unemployment in Kansas is greater than 4.5 but less than 6.0%, and 26 weeks if Kansas unemployment is greater than 60%. And the calculation for the unemployment rate is done at the beginning of the benefit year using a 3-month seasonally adjusted average. Under previous law, persons were eligible for a maximum of 26 weeks of benefits regardless of the unemployment rate in the state. If you will turn now to page 5 in the middle, during the 2015-2016 legislative biennium, we had 3 bills that were enacted that address eligibility for public assistance. The first was Senate sub for House Bill 2258, and that was commonly referred to as the Hope, Opportunity, and Prosperity for Everyone, or HOPE Act. And it placed authorization of the Temporary Assistance for Needy Families, or TANF program, in statute rather than by rule or regulation, which had been used to establish that program. The bill also modified and created certain definitions regarding requirements for child care, TANF assistance, and food assistance programs, and repealed other sections of public assistance. The bill also required an electronic check for any false information provided on an application for TANF and other programs by the Department for Children and Families, or DCF. There were definitions that were adjusted in this bill. Assistance was redefined to include food assistance and not food stamps or coupons. And aid to families with dependent children, or AFDC, was renamed as Temporary Assistance for Needy Families, or TANF. The uses of TANF were broadened to include meeting the needs of qualifying caretaker of a dependent child, and the definition of dependent children omitted the reference to a child who was deprived of parental or guardian support or care, a full-time student in a vocational or technical program, and expected to complete training prior to turning 19. And the definition made reference to children in the care of biological or adoptive parents or those persons appointed by the court to provide care. The bill also repealed the authority of the Secretary to extend by rule and regulation the deprivation of care requirement to children of parents or guardians who have been unemployed. There are definitions for general assistance and transitional assistance that were deleted, and instead we had the TANF diversion assistance that was added, which means a one-time voluntary payment option in lieu of ongoing TANF assistance. This was designed to meet the crisis that endangers an applicant's ability to remain in or accept employment. A household that has a recipient accepting a TANF diversion assistance was ineligible to receive an ongoing TANF assistance for 12 months following the payment of that diversion assistance. The recipient may receive a maximum of 42 months of TANF cash assistance during a lifetime if they receive that diversion payment. However, please note that that was changed later on to a maximum of 18 months in 2016. A hardship extension of no more than 12 months may also be granted at the discretion of the Secretary. With regards to TANF assistance and requirements, in the middle of page 6, in 2017, DCF is required, starting in 2017, DCF is required to conduct an electronic check for false information on an application for TANF and other benefit programs administered by DCF. The general eligibility for federal assistance was revised to include reference to cohabitating partners in addition to a husband and wife living together. And these individuals were required to register for work in accordance with criteria set by the Secretary by rule and regulation. Of note, a family group is ineligible for TANF if one household member has received the maximum number of months of TANF assistance under state law. And when determining eligibility for federally funded assistance, the Secretary considers the equity owned in certain personal property, as outlined here. An additional motor vehicle used by the applicant or the applicant's spouse or cohabitating partner for the purpose of being able to work is exempt from counting towards the personal property. All adults applying for TANF are required to complete work program assessment as specified by DCF. This includes adults who were previously disqualified or denied TANF due to non-cooperation or drug testing or fraud. Adults who are ineligible aliens or receive supplemental security income are not required to complete the assessment process. An adult is exempt from the work program assessment if the applicant can demonstrate any of the following: an existing certification verifying completion of the work program assessment, a valid offer of employment or is employed a minimum of 20 hours a week, the individual is a parenting teen without a GED or high school diploma, enrollment in Job Corps, working as a refugee with a refugee social services agency, or completion of the work program assessment within the past 12 months. TANF recipients are limited over a lifetime to receiving 36 months of TANF assistance. The bill allows the hardship assistance during an additional 12 months with the Secretary's approval if any of the following apply. The caretaker is a disabled family member living in the household. Disabled, which includes which precludes long-term employment or requires substantial rehabilitation, needing to overcome the effects of domestic violence or sexual assault, involved with prevention and protection services, and has an open social services plan, or is experiencing an extreme hardship as determined by the executive review team. In order to meet the mandatory work participation requirements, households are required to work at least 30 hours per week, which includes 20 hours of primary components and 10 hours of secondary components in one-parent households, where the youngest child is 6 years of age or older. And in two-parent households, participation hours are 55 hours with 35 hours per week if child care is not used. To meet the federal work requirements, those are listed in the middle of page 7. For two-parent families, it's similar to the state mandatory work requirements. For single-parent families with a child under the age of 6, the parent is required to engage in work or work activities for at least 20 hours a week in a primary work component. There's no additional requirement there for the secondary component. At the bottom of page 7, you'll see the definitions of primary components and secondary components and what those include. A parent or caretaker with a child less than 3 months of age is not required to engage in work participation. The 3-month limitation does not apply to a parent or other caretaker personally providing care for a child born significantly prematurely, with serious medical conditions, or with a disability as defined by the Secretary in consultation with the Secretary of Health and Environment. and adopted in rules and regulations. There are certain conditions under which the exemption from work participation for caring for a child under 3 months may not apply. Work experience placements are reviewed after 90 days and are limited to 6 months per 48-month lifetime limit. However, client progress is reviewed prior to each placement, and TANF participants with disabilities are required to engage in employment activities to the maximum extent of their abilities. If a TANF participant or recipient for child care subsidies engages in non-cooperation, which the bill defines, the penalty for the first instance is 3 months, the second penalty is 6 months, the third penalty is 1 year, and the fourth and subsequent penalty is 10 years. Individuals who have not cooperated without good cause with child support services are ineligible to participate in the food assistance program. If an individual is found to have committed TANF or child care fraud or found guilty of theft on or after July 1 of 2015, all adults in the family unit are ineligible for TANF for a lifetime. In that case, another instance where a protective payee would need to be named and receive approval by the Secretary to receive TANF payments and food assistance on behalf of those children. The bill prohibits the use of TANF cash assistance to buy specified items and in specified locations, and those are listed in the middle of page 8. Additionally, a photograph of a recipient on a Kansas benefits card issued by the Department for Children and Families used to obtain cash, food, or other services is to be placed on that card only with the agreement of the recipient. TANF cash assistance transactions using an ATM were limited in this bill to one $25 transaction per day. This limitation was later modified in 2015, another bill in 2015, to authorize the Secretary for Children and Families to raise or rescind the ATM withdrawal limit to ensure continued appropriation of the TANF block grant compliance with the provisions of the Federal Middle Class Tax Relief and Job Creation Act of 2012, which is the act that governs adequate access to cash assistance. No TANF assistance may be used for purchases at points of sale outside the state, and a benefit card that has a recipient's photograph is a valid form of identification for voting purposes. The HOPE Act also addressed child care assistance. The Secretary for Children and Families was required to adopt rules and regulations to determine the eligibility for a child care subsidy program and non-TANF child care support. DCF provides child care support for a maximum of 24 months per adult to those persons who are studying for degrees or certification that have an average job outlook. Other educational pursuits require discretionary approval of the Secretary. Students in this program are required to work for a minimum of 15 hours per week. In a two-parent household, child care support is not provided if both are exclusively going to school at the same time. The HOPE Act also addressed food assistance. Food stamps were renamed food assistance, and eligibility was limited to citizens and non-qualifying citizens as determined by the U.S. Department of Agriculture. Non-citizens who are unwilling or unable to provide documentation as defined by the USDA are not included in the household size when food assistance benefits are calculated. The Secretary for Children and Families is prohibited from requesting or implementing food assistance waiver from USDA for able-bodied adults ages 18 through 49 without dependents. The Secretary is not permitted to apply gross income standards for food assistance higher than those standards specified in federal law. Any person convicted on or after July 1 of 2015 of a felony involving controlled substances or their analogs is disqualified permanently from receiving food assistance. However, there is a drug treatment plan exceptions. Individuals are eligible for food assistance if they enroll and participate in a drug treatment program approved by the Secretary and they must submit to drug testing if requested by DCF pursuant to a drug testing plan. Failure to submit to a drug test or pass it results in eligibility for food assistance until that individual complies with the drug treatment plan approved by the Secretary. The drug treatment plan exception does not apply to any individual convicted on or after July 1, 2015 of a second or subsequent felony involving controlled substances or their analogs. Other provisions in the HOPE Act include the eligibility requirements for general assistance funded by non-federal sources. Those were repealed. And the bill also repealed the requirement for a list of all recipient names and addresses to be made available to the public. The Secretary was also authorized to negotiate debts or liabilities owed to the agency for purposes of providing child support enforcement services. Moving on to another bill in 2015, Senate sub for House Bill 2281 made several changes to Kansas law, and I'm going to focus on the one explained at the bottom of page 10. So turn with me to page 10, TANF Assistance and Requirements Amendment. The bill authorized the Secretary for Children and Families to raise or rescind the ATM withdrawal limit in order to ensure continued appropriation of the TANF block grant. And you will see that further, later on, additional action is taken in 2016 in this matter. Turning now to page 11, Public Assistance Eligibility, Step Therapy, and Medicaid. In 2016, House sub for Senate Bill 402, commonly referred to as HOPE 2.0, was enacted and made changes to TANF and other related public assistance programs. Additionally, the bill removes the prohibition from requiring a Medicaid recipient to use or fail with a drug usage or drug therapy prior to allowing the recipient to receive the product or therapy recommended by the recipient's physician. This is a practice commonly referred to as step therapy. The bill contained provisions regarding step therapy patient protections, expedited appeal processes for physicians to request step therapy override, and required study, review, and reporting by the Kansas Department of Health and Environment on the use of step therapy and any savings with that program. With regard to public assistance eligibility, the bill made changes to TANF and other related public assistance programs as follows. It reduced the TANF benefit limit from 36 calendar months to 24 calendar months with the possibility of hardship extension, allowing receipt of TANF benefits until the 36-month lifetime limit. The prior limit, as you recall, was 48 months. It reduced from 42 months to 18 months the TANF cash assistance lifetime limit for a recipient of a TANF diversion payment. Removed the limit on TANF cash assistance transactions for cash withdrawals from ATMs, and removed the authority of the Secretary for Children and Families to raise or rescind withdrawal limits. Required DCF to monitor repeated requests for replacements of the Kansas benefits card and refer frequent replacements for fraud investigation. It changed work participation requirements and exceptions for recipients of TANF, non-TANF child care, and food assistance, also known as the Supplemental Nutrition Assistance Program, or SNAP. It makes TANF and child care subsidy program recipients ineligible for assistance for failure to cooperate with fraud investigations, and required the verification of identity for all adults in the assistance household. It also required monthly reporting of persons with lottery winnings in excess of $5,000 to determine any recipient's continued eligibility for public assistance as a result of those winnings, and addresses the recovery of public assistance debt owed to the state. Details of these, all of those changes are located on pages 12 through 15. The TANF changes to eligibility include the TANF diversion assistance limit change and then the TANF lifetime limits. Of note, no extensions beyond 36 months will be granted, and the hardship provision applies to recipient who is determined by the 24th month of assistance to have an extreme hardship other than those described in statute. Hope 2.0 addressed the TANF cash assistance withdrawals from ATMs, as described before. They removed the $25 a day limit for TANF cash assistance transactions using ATMs, and remove the authority of the Secretary for Children and Families to raise or rescind the withdrawal limit. Additionally, regarding TANF work participation, TANF work experience placements are limited to 6 months in a 24-month lifetime period, excuse me. Other work requirements and exceptions in HOPE 2.0 include the requirement that each SNAP household member who is not exempt from work requirements is required to register for work, participate in an employment and training program, if assigned to such by DCF, accept a suitable employment offer, and not voluntarily quit a job of at least 30 hours a week. A recipient who fails to comply with those requirements is ineligible for SNAP for the following time periods or until compliance with work requirements: 3 months of ineligibility for the first penalty, 6 months for a second penalty, and 1 year for the third. Additionally, HOPE 2.0 provided that an individual who fails to cooperate with a fraud investigation is ineligible to participate in the TANF Cash Assistance Program and the Child Care Subsidy Program until determined by DCF to be cooperating with the fraud investigation. You'll see at the top of page 13 that it has information regarding the Kansas benefit card replacement and the procedures followed there: verification of identities, verification of lottery winnings for continued eligibility, and then the state recovery of public assistance debt. And I will be going over that. Except as authorized in state and federal law, DCF or KDHE rules and regulations and agency policy, the total amount of any assistance sold, transferred, or otherwise disposed to others by a recipient or another person, or the total amount of any assistance knowingly purchased, acquired, or possessed by any person is considered a debt due to the state. Such debt is recoverable by the Secretary for Children and Families or the Secretary of Health and Environment during the lifetime or upon the death of any recipient or person who sold, transferred, disposed, purchased, acquired, or possessed such assistance. The bill allows the debt to be recovered as a fourth-class claim from the estate of such individual or in an action brought while the recipient or person is living. There are further details regarding step therapy that begin here on the bottom of page 13 and go through page 15. I won't be going through those, but if you have any questions, I'm happy to address those. During the 2021-2022 biennium, unemployment compensation modernization was addressed, and during that, Senate sub for House Bill 2196 created the Unemployment Compensation Modernization and Improvement Council, required the Department of Labor to modernize its information technology infrastructure, made temporary changes to the membership of the Employment Security Review Board, made changes to employment security rate tables, required the Secretary of Labor to provide tax notifications and certain Employment Security Fund data reporting, provided for certain employer account protections, and provided for transfers of federal coronavirus relief aid to the Employment Security Fund and the legislature programs using state funds. Prohibits the continuation of federal unemployment compensation programs using state funds, and adjusted the thresholds for maximum benefits, modified the shared work programs, and made other employment security compensation changes. Details on those changes that were made by this bill are located in pages 15 through 18, and I will not be going over those in detail, as we don't usually deal with unemployment insurance in this committee. Ready for the top of page 18, if we're ready to move on there.
Any questions so far? So we kind of just looked at a couple major laws that were passed before I got into the legislature, the HOPE and the HOPE 2.0 Act, just revisions to a lot of the public assistance programs, a lot of details. And then the most recent was the unemployment insurance change in 2021, 2022 legislative session. I'll probably provide just a few documents at one of our future meetings with the trust fund balance, the unemployment trust fund balance. We don't really get into unemployment here in this committee a whole lot, but I think it's worth taking a look at what happened to the trust fund balance, the weekly payouts from the unemployment system, and then kind of take a look at those over time, and then we can see what these changes to statute did. What were the effects of the changes? And anyway, more on that when we discuss it, but I think that it definitely has effects. So we'll take a look at that at one of the future meetings. Okay. Any questions? Representative Humphreys.
So a quick question on the very front page, screening for cash assistance, and the secretary for DCF was supposed to adopt, or may adopt rules and regs, but there weren't any rules and regs. But that was in 2013. So did that kind of get swallowed up with the HOPE Act and TANF and everything? Okay, so.
When we updated the memo, we did go back and look, and there were no changes, no rules and regulations. I think because the HOPE Act and HOPE 2.0 did address a lot of the details.
And do you remember what committee the HOPE Act went through? We didn't have this one. I'm just curious. That's just an odd question, but just curious what committee that went through.
If I recall correctly, I believe it went through one of the health committees.
Okay. Yep. Okay. All right. Thank you. Thank you, Mr. Chair.
Representative Barth.
Thanks, Chairman Auerkamp. I had a couple of questions. My first question, it was on SUI also, actually, interestingly enough. So can you tell me, is the department staffing that in person for unemployment claims and filings? Are we working in person back in office, or is it still virtually from home?
I'm sorry, Mr. Chairman, I don't know the answer to that. That's something the agency would need to provide. I'd be happy to look into it.
So I think from Department of Labor, the legislative liaison or person to direct a lot of the communications to is Julie McNeely. If you need her contact, she's excellent as far as getting back to you with a lot of the answers to questions and anything to do with the unemployment system.
Okay. I just know there was part of it, and I know that's been one of my top constituents' issues is even getting a hold of them. I don't know if they're staffing back in person now, but that was a concern up till last year as well. My second question here is around the photograph of a recipient, and this might be a silly question, I don't know, but it says only if it's agreed upon. Like, why do we have it on some and not others with a photograph of someone? Is there a reason for that? It's on page 8. Mm-hmm. It's in the middle of the page.
Mr. Chairman, Representative Barth.
Kansas benefits, it says card issued by DCF, which is used to obtain food, only if agreed to by the recipient.
I'm not sure why that was decided, why that was made part of this particular legislation. Some recipients did not want their picture on there. They might have had other forms of identification, but they could have that choice if they wanted it on there.
Just found it interesting. Okay, thank you.
Okay. I'll pick up on page 18 at the top, under food assistance work requirements for able-bodied adults without dependents. This was in 2022 in Senate sub for House Bill 2448 and required DCF to assign all able-bodied adults without dependents, and the acronym uses ABODs, subject to SNAP work requirements established by federal law to an employment and training program as defined in federal law. The provisions of the bill apply only to ABODs ages 18 through 49 and only to individuals who are not employed at least 30 hours a week. And in 2023, there was the public assistance eligibility for child care subsidy and employment and training program requirements for food assistance that were addressed in House Bill 2094. And that bill continued the existing statutory requirement that parents cooperate with child support services administered by DCF as a condition of receiving child care subsidy and maintain the periods of ineligibility for a child care subsidy for non-cooperation. The bill required the Secretary for Children and Families or the Secretary's designee to review the parent's child support compliance at certain specified times. And the bill also amended law pertaining to eligibility requirements for SNAP to require work registrants ages 50 through 59 without dependents who are not exempt under federal law to participate in an employment and training program. Regarding non-cooperation with child support services and the child care subsidy disqualification, first, the timing of child support compliance reviews. The bill requires the Secretary or the Secretary's designee to review child support compliance of parents applying for or receiving a child care subsidy upon application for child care subsidy after 12 months of continuous eligibility for the subsidy and following 12 months of continuous eligibility when the Secretary was reviewing and or determining a parent's ineligibility for the subsidy. The periods of ineligibility for child care subsidy for a parent's failure to comply with child support services continue with an additional condition that noncompliance reviews occur at the specific times outlined in the bill. The periods of ineligibility for child care subsidy or for noncompliance with child support services in continuing law follow on page 19. First penalty is 3 months in cooperation with child support services prior to regaining eligibility. For the second penalty, it's 6 months in cooperation. The third is 1 year in cooperation, and the fourth penalty is 10 years. We also had House Bill 2094 that was enacted in the 2023 legislative session, and it amended law pertaining to eligibility requirements for SNAP. The bill required DCF to assign work registrants ages 50 to 59 without dependents who are not exempt under 7 U.S.C. Section 2015 D2 to an employment and training program as a condition of participation in SNAP. Under continuing law, able-bodied adults ages 18 to 49 without dependents and individuals who are not employed at least 30 hours a week are required to participate in an employment and training program to receive SNAP. I have before you at the bottom of page, in the middle of page 19, the reference to the USC. It's a federal law that exempts the following work requirements, work registrants between the ages of 16 and 59 from a work requirement. And that's for an individual currently subject to and complying with work registration requirement under another federal program or a federal state unemployment compensation system, a parent or another member of the household with responsibility for the care of a dependent child under 6 years of age or of an incapacitated person, a bona fide student enrolled at least half-time in a recognized school, training program, or institution of higher education, except that such person enrolled in an institution of higher education must meet additional requirements, and a regular participant in a drug addiction or alcoholic treatment and rehabilitation program, an individual employed a minimum of 30 hours per week or receiving weekly earnings that equal the federal minimum hourly rate multiplied by 30 hours, or a person between the ages of 16 and 18 who is not a head of household or who is attending school or enrolled in an employment training program on at least a half-time basis. There were no changes made in 2014 to any public assistance programs. And I am happy to answer questions.
Quick summary, we had talked about the HOPE Act, the HOPE 2.0, some unemployment, and then some changes to what's called ABODs, able-bodied adults without dependents, and requiring employment and training programs in order to continue to receive SNAP food assistance. And I have not seen it, but I think in the presentation last Thursday in Social Services Budget, Secretary Howard or DCF made a presentation and they had a slide about the employment and training programs effects or some of the results they're seeing. I will try to track that down and then see if I can get a copy of that slide and provide it to the committee. So, any questions, committee? Seeing none. All right. Thank you very much, Idida. Next up on the agenda is a hearing for House Bill 2027. And this is the reorganization bill that just restructures the public assistance statutes. We do not have anybody to testify, but we'll go through a kind of a review of the bill from the Office of Revisers, Jenna, and take questions. Go from there. All right, welcome, Jenna. Thank you.
Thank you, Mr. Chair, and good afternoon, committee. I'm Jenna Moyer, Office of Reviser of Statutes, and this will be House Bill 2027. If you notice that the provisions of this sound pretty familiar, it's because this is very, very similar to the one that you saw last week with a couple of technical corrections, which I'll go over. And so this bill proposes a reorganization of the public assistance program sections in KSA 39709, and the bill has the statute now being organized by public assistance program, which would generally be subsection A, would be general eligibility for assistance for which federal monies are expended. B would be temporary assistance for needy families program. C would be food assistance program. Subsection D would be child care subsidy program. Subsection E would be fraud investigations. F, drug screenings and convictions. G would be assignment of support, rights, and limited power of attorney. And H would be related to that electronic benefits card. Subsection A goes over the general eligibility requirements in order to receive cash assistance, food assistance, and child care subsidies. And those requirements in current law include income, citizenship, and residency in Kansas. Each subsection includes all current statutory requirements for the corresponding program, except that more general requirements related to drug screenings and convictions, assignment of rights to the secretary, and the EBT cards are organized in that item's own subsection. Each section includes a provision that eligibility for the corresponding program is subject to the corresponding requirements for drug screenings and convictions found in subsection F. So in order to qualify for any of them, you have to qualify in subsection F. And the bill does not amend subsections related to the Medicaid program, except for correcting references due to reorganization of the subsections. And this bill also cleans up references in 39757 of KSA 3709. And the three areas of changes, if you look really closely, you may be able to see from the draft you saw last week. On page 3 of the bill, where it says TANF, it'll now say temporary assistance to needy families or TANF, and that will be in paragraph 3 there. So it says or TANF, and then throughout the rest of the bill, all the sections should then just say TANF. And then any references to secretary for children and families will now be corrected to secretary, because in KSA 39702, there is a definition of secretary, and that says that secretary means secretary for children and families. So that way we can have a brevity of terms there. Unfortunately, there is not a definition for Department of Children and Families. So each time in the bill that it says department, they all have to say Department for Children and Families. There are a few instances in which the statute says Department of KDHE. So just to keep it clear, they all have to say Department for Children and Families. And then on pages 4 and 5, I corrected an age references. Consistency, and the typical way we refer to age in statute would be X years of age. Instead of age 5, age 6, we would say 6 years of age. So I added those on page 4 and 5. Those would be in sub-clause. It would be 4. So IV would be line 33 on page 4, and then lines 23 and 30 will now say either months or years of age. And after the bill brief, there's the little nice chart that Jesse so generously made for me that I can pass along to you that'll just say where you can find everything, where it's reorganized. And I'll be happy to answer any questions.
Thank you very much. And just once again, a lot of changes, but after going through this several times, I know Jesse went through it several times, we reviewed it last year. Best of your knowledge, there are no policy changes. Everything remains the same. This is simply a reorganization of the current contents in a more, can I say, logical fashion.
Correct.
And as kind of stated at the previous meeting, this is a project I asked the Office of Revisers to do about a year and a half ago during the break. And I said, make it what you would like it to be as far as reorganizing the statute. Any questions, committee? Representative Humphreys.
Thank you, Mr. Chair. Can you remind us or Revisor what happened last year? Did we pass it out of committee or did we ever vote on it at committee?
It was my understanding that it was passed out of committee, but it did not come up above the line on GO.
Okay, great. Yeah, I mean, okay, that's it. I mean, I'm sure we'll talk about it later, but yeah. Thank you.
Representative Owsley.
I know, thank you, Mr. Chair. I'm trying to wrap my head around the intent of this. I mean, because, you know, like in child welfare, we deal with the sync code a lot, and it does need revised now and again, but I don't think I've ever requested a judicial council review to just reorganize without any revisions. And so I won't question the intent, and if it doesn't change policy, you know, happy to hear it, but I just puzzled, that's all. Mr. Chair, is this what keeps you up at night?
No, nothing really keeps me up at night. I sleep very well. Regarding the intent, you know, we all have our personal backgrounds, what we do for a day job. And yeah, I work in a manufacturing business. There's an approach to kind of work, kind of from lean manufacturing. It calls the 5 S's. And if you kind of take a look into that approach to work, you know, the first step is often to kind of sort what you're working with. And then you set it in order, and then shine it, refine it, standardize, and score. And it's kind of a universal approach to any project management. And so when we started looking into the welfare statutes as a committee, one of the first things that was recognized by the committee, I believe, was that the current statute was not structured well. It was very confusing and didn't have to be. And so when there was a question to the revisers to research, it was often difficult to answer the question because of the references to that specific program in multiple areas of the statute. And I've always taken the approach, even back when I was on a small planning commission in the city, that, you know, government has an obligation to be easy to understand to the people it represents. And so even when I was on a planning commission, took several hundred pages of zoning code and restructured it so that it was easier to understand. And I think it's the same approach here. There's no reason for statute to be confusing. And so that's the intention, is just to simply make it as easy as possible for the revisers, research, and the legislators, and also the many people who have to work with these programs. Just make it easier for them to understand the law so that they can follow it.
Can I just say thank you for that context?
Absolutely.
Thank you.
Representative Carr.
Thank you, Mr. Chair. So would that be, coming from a manufacturing background myself, the first thing that comes to mind when I think of the 5 S's is the simplify portion of that. So would that mean that during this exercise, since we have this open, that we could go in and simplify many of the portions of the statute that might be a little more confusing and detailed?
Absolutely. I think, and just so you know, I do intend to work the bill on Thursday. So if there are ideas to simplify the bill with amendments, please bring those to the committee on Thursday.
Thank you, Mr. Chair.
And if I could clarify, there have not been efforts to simplify language that would affect policy within this.
Representative Humphries.
Just also just a point of clarification, and I could have misheard something that Representative Owsley said. When you didn't ask the Judicial Council to do the review, it was just the revisor. Yeah, I just wanted to make sure that the person that did all this work got commended for that. So I know it was, but I think maybe you said Judicial Council, but maybe not. I could have.
Thank you, Mr. Chair. And I might have misspoke, but in the discussions that we've had on the sync code, the Judicial Council has always been involved because it's a rather large undertaking. So I agree with you. Credit due to the Office of the Revisers, but I was just making a statement.
And just kind of, I think we'll have plenty of opportunity, certainly when we work this bill, but there'll be other bills coming through the committee over the next several weeks that are more policy driven. So there'll be a lot of opportunities to discuss specifics on policies and bring as many amendments as you can come up with. Any other questions, committee, for Jenna? Seeing none, thank you very much. And once again, I do want to work the bill on Thursday. So I guess get with Jenna if you have any amendments. So that was the kind of the memo on the bill. We don't have anybody to testify that's come and let Gary know, but are there any proponents of the bill? Anybody like to, any opponents for the bill? Anybody like to speak neutral on the bill? Seeing none, we're going to close the hearing on House Bill 2027. And before we wrap up, committee, last Tuesday, we went around the room and gave introductions. Representative Barth was not here, so just same thing. We asked, speak more than less. Tell about your background, and also, if you can, expectations for this year on the committee.
Thank you, Chairman Auerkamp. Representative Carrie Barth for House District 5. I live in Baldwin City, Kansas. I am new to the Welfare Reform Committee, so I have some catching up, I think, to do a little bit. Some of this has some crossover from the two committees I served on the last two sessions, so that would be the Social Services Budget Committee as well as the Health Committee. I think there's a lot of the same departments that are part of this, so I don't have a ton of experience in this, so some of this will be new to me in learning a little bit, so bear with me on questions that I ask as well. Also, background-wise, professionally, I am a sales professional, and I work with companies, and I help them with affordable healthcare benefits and in an innovative way, in a new way that is not just the traditional insurance business. And I would also like to take a real quick point of personal interest and introduce my intern that's here today, if that's okay too. So I have an intern that is with me today, Olivia Fonseca. She is a student at Washburn University, and if you see her around, please, welcome her and say hello to her. Thank you.
Thank you very much. So with that, I don't have any additional comments. I think we'll work the bill, attempt to work the bill on Thursday. I might ask for a presentation by research. It'll be a short one, just on a couple topics. and we're trying to line up some hearings for next week. I think tomorrow, the cross-check bill will get read in. And yeah, it'll be tomorrow, it'll get read in on Wednesday. And we'll probably have a hearing on that next week. So if there's any further information on Thursday to provide on that, I will do this. So any comments, announcements from the committee? Seeing none, we are adjourned.